Another great question that often gets asked, what will it cost? And the attorney answer again is, it depends. Until we have a chance to sit down to discuss what a client wants to do, we don't know what it to recommend. If an attorney can answer that question without spending time with you to determine what you need, then all you're doing is paying to rent the word processor. The it you receive will be the it he produces for that cost. It's the lawyer's plan, not necessarily your plan. For example, several years ago, I had some potential clients come in for estate planning. They followed our process. They submitted their information ahead of time so that I could review their current situation and prepare for our meeting. Spent a couple of hours going through their information. During our meeting, we discussed his kids, her kids, and whether they would eventually have our kids. We discussed what their concerns were with the kids, their abilities. We discussed how they wanted to treat the kids in their planning. His kids, her kids, are they really our kids? A lot of time was spent on discussing disability issues and how they wanted to be taken care of, what instructions we should include in the plan for their care. We spent 2 hours reviewing their concerns, their needs, discussing the options. During our discussion, I worked with them on my planning model to design a plan outline to address what we were discussing, as well as all of the what-if questions that I raised with them. The attorney is supposed to address what if, make sure that we cover as much as we can. After the 2 hours, not including the time spent in advance getting ready for our meeting and analyzing their current situation, I quoted my fee for the planning if they wished to go forward, and we signed a fee agreement. They paid their retainer. The next morning, they called me and said, we called another attorney in town and asked him how much to do a living trust for us. And he said, I'll do it for 1/3 of your fee. What's the difference? The difference? The other attorney answered the phone and was asked, how much for a living trust? And gave you a quote for his document he prepares. We spent 2 hours reviewing your situation, discussing options for you at each phase of your life, and gave you recommendations based upon our discussion. We prepared a design based upon that. We are preparing an it. We are preparing your specific estate plan, crafted to meet your needs, and then funding that plan to make sure it works. The other attorney is going to fire up his word processor, search and replace names, produce his document that meets his definition of your living trust. Will it meet your needs, client? That's hard to say. It'll be the trust that he drafts for everyone at that price. He isn't spending any time to determine what you need, and at 1/3 of what my fee was quoted, he's probably overcharging for his word processor. I did ask that potential client to come back in and pick up his retainer check because I didn't think we were a good fit as attorney and client. I don't charge for the initial consultation. That's both of our chance to determine, are we a good fit? Our charges are based upon our legal counseling and not solely upon production of documents. If we both determine that we are a good fit as attorney and client, and I have a good idea on what my recommendation will be, we can then quote our fee and design your estate plan. If you decide that you aren't ready or our relationship is not a good fit, we'll part ways at that point with no hard feelings. As part of our trust-based planning, we believe in fully funded trusts. That means that while you are alive, we transfer your assets to your trust so that in case of your disability, your instructions are followed without relying upon the court or any other third parties. At death, we want our only contact with the probate court to be mailing of your original will to the court as required by Michigan law, but no probate matters to be started. Funding will be accomplished working closely with you and your EWM advisor to determine the proper titling of assets and naming of beneficiaries in accordance with your plan and your goals. With beneficiary designations, I like to build in tiers with contingent beneficiaries, because that gives us some flexibility to use disclaimer planning post-death. With EWM Legal Services, you aren't buying an IT. You are engaging with us in legal counseling to design your plan, executing your plan, and then taking steps to make sure your plan works as designed. We believe that estate planning is the foundation of protecting what you've built, not just providing an IT. That protection is for you while alive and well, for you and your loved ones while alive and not so well, protecting your loved ones and the assets you leave for them, and getting those assets to them the way you want, when you want, and how you want.